Hello.
Hey, there we are. Welcome to Spin Legal. It is May 12th, 2026, episode 116. And today we're talking about why do people misunderstand the law? But hey, it's one thing needs to be said today. It's Census Day.
Well,
Right?
don't we have all this stuff like where people get to read their Miranda rights and they have the First Amendment rights in
Oh, you
Canada?
mean for not filling out your census?
Oh yeah, people think that, oh well, this is going to give it to the government, isn't it? Nope, fill out the census.
Yeah. All right. Okay. So if you need to contact Invictus Legal on, you can do so on 905-688-5598. Email Angela with Angela at weareinvictus.legal or myself using Peter at weareinvictus.legal. And we are invictus.legal. Yes, we are. Okay. And so the big opening question of the day is, why do people misunderstand the law? And I think that if we're honest about it, hey, one of the things I used to do back in the day was I had a lot of people who misunderstood technology, right? So a lot of people didn't really understand what the heck computer technology was about, and I think there's a similarity with the law. So we've got a lot of language issues, and
They watch Law and Order in the United States. They watch criminal law. They watch movies where there's a jury, and they practice Boston Legal. Of course, they know the law because they watch all of those shows. And even Canadian law, when they had Street Legal and all these other shows in Canada about Canadian lawyers.
Well,
Yes.
and of course, what and again, there's one that I've got to always ask the question: what self-respecting lawyer is going to practice out the back of a Lincoln?
Yes, exactly. Exactly. Or out of their bedrooms or out of some kind of a dinky apartment.
Yeah.
I mean, basically, that's what they set these offices for, law chambers for people who don't want to have a full office. They can go to a law chambers.
Yeah.
And then they have the support there.
Yeah. Okay. So this leads us to the next question, of course, is convoluted legalese. The language is often deliberately technical, and when I say technical, some of it's actually not even in English, is it? For crying out loud, half of our law is written in Latin.
Yeah, some of it's Latin phrases that come out, and then some of the legal terms that are English terms are actually very specific, and they have whole specific meaning. Like Black's Law Dictionary is a source where people can look and see definitions of certain terms.
Yep, got one of them.
Yep, we do.
Somewhere at home. Yep, I've got one of them. And yeah, you're right. Sometimes you kind of, and there are a few words that have, and examples escape me, but there are a few words where you use the word in normal English usage and it means one thing, you use it in the law court and it means something entirely different.
Yeah, and this is the thing, like when people understand things, like they go, this is, but don't I have Miranda rights here, or First Amendment rights? This came when the people from the Truckers Convoy, when they arrested a few people because they were leading the demonstration, and they went to court, and some of them went in there and it says, well, I wanted my First Amendment rights, and now I'm being brought up on charges.
Yeah.
It's distortion of reality. It was not about their speaking out. It was about what they did. It was more about their behavior and what happened, So it's so people have to understand why people get charged.
Right? Well, I was going to say one of the things we get is it's the USA has a big impact, and obviously here in Canada we are bang next door to the USA. If we were to reach out far enough, we can shake the hands across the border, can't we?
Yeah, exactly. Well, we're pretty close to the border.
Sorry?
We're pretty close to the border.
Yeah, I live less than a mile away from the border, so I could walk down to River Road and wave at them. Hey, America! The trouble is, with doing that, they might turn around and try to shoot me.
Be too many girls. They're probably all standing there and making sure nobody gets across because they don't want any immigrants.
Well, yeah. But again, it's curious about USA because we operate English law, don't we? The basis of our legal system all comes from the little island across the Atlantic called England. Well, half the island called England. Because we operate under English law more so than we do under, Welsh law is completely subjugated to English law, and Scottish law kind of butts up and fights English law in certain circumstances. But, it's all comes from English sources, even the USA law.
Mm-hmm. Yeah,
right?
Exactly. Like the U.S. uses English law to do things, to interpret their own legislation and their constitution. And the thing is, what people don't understand is in Canada, we have more of the separation of powers where we don't have a prime minister or ministers that can tell the courts what to do.
Yeah.
We don't even politically, we to some extent, we appoint our judges, but they're not based on a political basis. We don't appoint people because they contributed enough to the political party in power in order to determine that they should. Whereas in the United States, there's a lot of partisanship in terms of.
Well, I always thought at one point I did actually think that the idea about judges being elected was a good thing. Then I asked some Americans, how do you go about electing a judge? And they go, I don't really know. I don't know what makes a good quality of a good judge.
Yep.
And other Americans told me, well, the ones who get elected are the hang 'em high type.
Yep, exactly. And they don't necessarily will interpret the law in a neutral manner.
Yeah.
Right? Because right now they're more beholden to the people that voted for them, as opposed to being beholden to the Constitution and the law.
Yeah.
In Canada, we have judges that, people say, well, how come they're letting this guy out on bail? Oh, how come this guy gets only a short sentence? I don't think a lot of people understand what happens in the courts and why the courts make certain decisions.
Yeah.
Okay? The thing is, these things are based on a set of laws, constitutional issues, and as well as perhaps even the circumstances of the person, okay, where they make a decision. There's something in the United States, they call it the insanity defense. Up here, it's not the NCR, not criminally responsible. Not criminally responsible, where they are not, like they would be in a state of mind where they're not able to understand what they're doing is wrong.
Yeah.
Okay? So these sorts of things happen, and then just say, well, they just killed everybody. Oh my God. And the thing is, many times if you go there and you study the case and you've actually been in a courtroom and watched it, and you'll find that the Crown often agrees with the defendant, not because the Crown just wants to let the guy go. This person ends up in a treatment facility, sometimes for an awful long time.
Yeah. Well, that was actually brought up. That was brought up in relation to the Yorkshire Ripper in England in the late 80s when they caught him. There was a whole heap of issues surrounding that. And one of the questions when they went to the trial was the actual judge refused to allow an insanity defense. Because he didn't want to see them going to, an insane asylum,
Mm-hmm.
right?
Yeah.
because
these things are carefully considered because you really require a panel of experts to examine and to review the person and also understand the person's history, a number of things. There are some people who commit less serious offenses, and they get NCR, but they're not labeled NCR. It's called diversion. Right? So there's a number of situations in the court system where people have to, and these are things that are court ordered. Like a person would have to continue to attend mental health services or to seek drug treatment or to seek counseling. These are things that are court ordered, or they're put on a probation where the probation officer has the authority to direct them.
Yeah. And ultimately media and pop culture seem to distort reality, because you hear a situation of, oh, they let this person out on bail, and the judge who actually decides whether there's a bail or what the conditions of release are, and generally speaking, unless you've committed a more serious crime in Canada, there is a release. We have a release situation. Now, is it arguably too lenient? One could make that argument. It's a good political argument to make, but the way that our system currently is, unless you were to actually amend the law, or you have an executive order that would effectively amend the law, it's very difficult for the judges to do anything but what is written in the law.
Yeah, you have to go through Parliament and then through the Senate and to make a change in the law, and people have to be able to go speak to the committees that are responsible for making any changes.
And then of course you get the furor in the media, which often blows things way out of proportion about particularly criminals being released on police bail, police on their own recognizance, etc. But in fact, there are conditions there.
Yeah, they have conditions, and if they do breach the conditions, back to jail.
Yeah.
And these things are these are things that people have to kind of understand. Like, all you hear is the one thing: oh, we're just catch and release system.
Yeah.
Oh, it's all the liberals. The liberals have nothing to do with what happens in the courts. Okay, the judges have to make a decision.
Sure, a more conservative government could come in and could change the law.
They could say,
make sentences harsher. That's always the prerogative of Parliament.
They can say, come in, and they can say nobody gets bail. And you know what's going to happen? Constitutional law, constitutional litigation would be going all over the place, and it'll cost the government so much money they will have to change the system back. And then, how many jails do you really want to build? How much tax dollars are you willing to spend?
It'll keep the building workers it'll keep the building workers going for the next 20 years.
Yeah, and it's not necessarily the best way to approach this type of situation.
Yeah.
So, I mean, there are countries in the world that actually handle this type of situation much better.
Yeah.
Yes, there's always going to be bad cases, but bad cases don't make good law.
And again, there are many bad cases. There have been many bad cases whereby people have been found guilty for terrorism and things like that just because they were Irish.
Yep.
It's an English example, but there's unfortunately too many of them. They had that Irish accent, so therefore they went to jail for murder they didn't commit.
Yeah.
Right?
And they've done that here in Canada. There were several people committed to jail for life, and they did not commit the crime.
Yeah.
After they started discussing and discovering DNA. Yeah. So somebody spends 22 years behind jail in behind bars, and they these things often end up where the taxpayers are going to have to compensate them somehow, because whether they're going to be able to get a job after, resettle themselves, there's a lot of issues around that.
Okay, so one issue here is what's called so justice versus procedure. Many people believe that the legal system is primarily about absolute justice, about, hey, they committed murder, bang them up for the rest of their lives. In reality, there are a lot more concerns with the resolution of disputes, etc. And be honest, it's not just, you can't just bang them up for the rest of their life. Hey, he stole a safety pin, therefore bang him up for the rest of his life.
Yeah, justice does not exist in the legal system. We have a legal system, not a justice system.
Yeah.
And when you have a legal system, there's procedures put together, there's precedents, there's processes, and everything is put together. You need to learn these laws, and this is how people who work in the legal system get trained about how it works.
Well, and the other thing that we've got to also think about here is the user, the legal system user only has partial knowledge, and sometimes a little knowledge is a bit dangerous, isn't it? Right?
Especially when someone says, "Oh, I know about criminal procedures. I'm thinking to lay private criminal charges." So I will go out and start doing it, and then they discover that really the Crown says, "No, I'll take it over," and then I don't think it's in the public interest to continue.
Yeah.
These are things where you have to understand that, hey, find out what it is that you can do, what process you need to do. I used to call them the silos. What silos you need to fit your problem in, and then work through that system, right? And how to do it, because some of them have multiple silos to choose from, but each of them you have different types of avenues to pursue.
Yeah. All right. Because the thing is that exactly the reason why you need to have a lawyer is, a legal person in your corner, is because having a partial knowledge is sometimes very dangerous. It's like, so there's a tenant who told me, I know everything about landlord and tenant law because I've been going to the tribunal since I've been unemployed every day for the last 3.5 years.
Oh, I've been taken to the tribunal several times, so I know a lot about landlord tenant law.
Yeah, that's the other thing.
Yeah.
But again, one of the questions about that is that, so you go and you see a case, and it's Smith versus Jones, and it's interesting to watch the case. But how often do you go and look up the results on Canley of Smith versus Jones? What was decided by the adjudicator? I've been to several where I've looked at witnesses and say, you're a lying whatever, right? And one case, I looked at a landlord, and God, was he lying. Then I looked at the tenant, and I thought, oh my God, you make the landlord look like an angel.
Like I've been going in there, I whisper, I like rocks.
So if I were to go look that decision up, I'd probably find an adjudicator that was pretty well, following my logic about that. Which side am I going to side on? The one who lied the least to me.
Yeah.
Right. So this is where having a partial knowledge can be very dangerous, because
I've seen people like they have a little bit of knowledge when they go to court, small claims court, they represent themselves, especially when they like to sue everybody. I think usually about the same thing. So they go to small claims so they can just do this, or they sue people, and guess how much they sue them for? $50,000.
Yeah.
Isn't that interesting? These self-reps always sue for $50,000.
Yeah.
And they don't understand how to evaluate, how to make that claim so that they can prove that specific claim.
And the interesting thing is that if they break it down, you see, if I'm suing for $50,000, I'm going to probably have portion A, which is $17,112 for materials, wasted materials and wasted customer time and effort, because due to the breach of contract.
Yep, exactly. And why?
So it's detailed out.
Explain this is time, this is money, or you had to go hire another contractor to fix the problem, and this is how much you paid the other guy. You know, so there's a lot of stuff that that people are very, you know, it's like sometimes I've seen some very good self reps, but most people who are self reps, they don't do themselves a favor.
Mm. Well, we used to have a gentleman.
You don't do yourself a favor, and sometimes if you actually get into a trial, you're risking having costs against you if you can't your case.
Well, we had a gentleman a while back who used to come in probably once a month because he was getting affidavits signed on superior court documentation that he was presenting to the court. He had a raft of cases all going through the judicial system, some even in the Supreme Court of Canada.
I remember he came in. Yeah.
And he was very precise. And I read, you know, because we take a copy of some of those documents, we have to for affidavits and the like. I actually read one of his documents, and it was very well founded, very logical, very.
So this was one person that was actually very well put together in terms of his ability to organize himself as a self-rep.
Yeah.
Okay. Like sometimes self-reps, many times they'll work with a lawyer and just say, is this something that should be written or whatever? And the lawyer might give them some summary advice, but they would go on their own because they want to make sure, trying to save money that way. But there's a lot of people who just go on their own because I know my case, I know the law. It's simple because the judge will listen to me when I get presented.
Yeah, and then when you get into the court, Mr. Jones, I'm sorry, your case, it says the judge, Mr. Jones, I'm sorry, but your case makes no sense whatsoever, and you're adding 15,000 minimum to any likely settlement, and I'm sorry, I can't even see me offering you 2,000, let alone anything else. And do you have a negotiation
settlement conferences at small claims court? And a lot of times I've heard judges talk to self-reps and said, do you have legal representation?
Yeah.
Maybe you should talk to somebody legal.
Yeah.
Okay. And they'll be asking some questions about it, you know, because there's issues, and he'll talk about the risk of costs and different things.
Yeah. Yeah.
Okay. So this is where people do a lot of this stuff, even in landlord-tenant court, where there's not a lot of risk of cost, but losing the case, you know, it's like, especially against your landlord, if your landlord's got a serious claim against you because you're 12 months behind in rent, okay, and then you're claiming is this, but he didn't fix my leaky sink, you know. Like,
but again, the adjudicator, even if but he didn't do my leaky sink, the adjudicator is going to go, okay, $12,000 owed rent, $99 for a leaky sink.
Yep, exactly.
They don't add up, right?
Yeah, exactly. There's going to be, like, one has to think about these things before they jump into it. And our knowledge of law is, because people think that the legal profession is somehow glamorous, and many people aspire to get into the legal profession because they think this is going to be something where, hey, you'll get a lot of respect. You don't. Okay. It's a very difficult profession. Okay. Sometimes you'll get some interesting cases and they're able to work into different things, but it's not a profession where you go in there and everybody appreciates it. Not everybody appreciates the work that you do. And some people really appreciate your work. And your opposing counsel sometimes would, you know, it depends, you know, although this profession, you know, where we are bound to try to be collegial to a co-counsel on the other side. And we try to be respectful when we attend court. So there's a lot of rules that we have to follow.
Yep.
Even though sometimes you want to punch somebody in the face because they're the opposite and they're saying things that are ridiculous, you know, we can't do that. Yeah. And we can't even say something like that. You know, you have to be extremely careful. And the thing is, Like I remember there was a story I read about Colonel Sanders, hey, before he became a chicken guy. He actually tried his luck at being a lawyer.
Yeah,
And he
I
got in a fist fight in a courtroom.
heard,
It
I heard
didn't work. He had to get
Judge
out.
was not that impressed.
Yep. Yeah, exactly.
It was like, yes, if you want the Marquis of Queensberry rules, outside.
Yep, exactly. So these are things, that people get in and to understand. And also too, there's people who read these books. You and the Law are update on Canadian law. Yeah, they're interesting and they'll give you some general information, but they don't give you the law and the technique.
Yeah.
Okay? Because they don't tell you how to go and fight a traffic ticket. They don't tell you how to fight your case at landlord tenant board. They don't tell you how to fight and to succeed with appealing a benefit that you're applying for.
Yeah.
These are things that you go to lawyers and paralegals about,
Yeah.
and
Yeah.
they will help you do these things.
Well, actually, there's another point that we have to also point out in this regard. The law is evolving. If you were to take a cross section of the law in 1750, and quite apart from the technological differences, and you were to take another cross section in 1995, apart from the technological differences, there'd be a lot of common factors. Like the law of contract is exactly the same in 1750 as it is now. There's certain things you have to do in order to run have a valid contract. There's certain things there's terms and conditions that mean certain things, and 90% of the law of contract will be the same in 1750 as it was in 1995, right? But the point being is that the whole of law develops. Why we have Parliament is there to actually rectify some of the issues that we have in society. And it's true that we set up laws about CB radio and cell phones,
or the courts settle these things, because employment contracts in the last 2 to 3 years alone, there's a number of court cases that actually change the way employment contracts are drafted. Okay, so this is very important. So you might get a book from 1990. It talks about employment law.
Yeah.
Some of it's good, but not all of it. You have to understand how the whole picture is, because employment law comes from many different sources.
Yeah.
Not just Employment Standards Act, but there's a common law, there's WSIB, there's disability law, there's rights code, whole bunch of things you have to consider.
Yeah. And irrespective of what your political position is, that law advances one way or another over time. So, politicians put in a new reform that allows certain rights, and now they put in a second reform that takes away some of these additional rights but adds new rights. So that's the development of political, of legislation over the years. And one of the questions that I've seen that I would say is that I think some of the laws that were put in, big bang, well, we've got to do this, we've got to answer now, right? Some of those laws that were put in 3 weeks or a month or something like that are often the very ones that the courts and the Superior Court have problems with. So those are the ones that come back year after year after year. That is the definition of whatever in this law is wrong, right? It doesn't accord with this law and that law and the other law, and how we might understand at the courts. And I have to actually implement, and the judge is going to say something like, I have to actually consider the natural meaning of this word, because of the fact that how is the man on the street going to understand it if he doesn't understand the natural meaning?
Yeah. And the thing is, a lot of people, they'll say, oh, these activist judges, they want to change the laws. No, they don't. They don't. What happens is somebody brings it to their attention that a particular law may not pass constitutional muster, Or there might be something within Human Rights Code where when it was drafted, the Human Rights Code was not considered.
And in fact, actually
put into place.
But in fact, actually, I think judges are less, if you wind the clock back 150 years ago, common law was making a lot of new advances on new laws. Today, there tends to be some common law applications to statutes that actually limit the scope or extend the scope of statutes as they need to. But the vast majority of new laws are coming from statute, not from common law.
Yeah. Like, for example, if you're looking at the Residential Tenancies Act, okay, these things have been changed well over the years. It started off as a Tenant Protection Act when I started practicing in the tribunal. Then in 2007, it became the Residential Tenancies Act. And then over time, there were some additional changes. 2018, there was some additional changes. 2021, additional changes. And then now there's some recent changes. What happens is there's people who go to the legislature and they lobby and they're saying, oh, we need more rights for landlords. Oh, we need more rights for tenants. And there's different situations which they put forward. So the government tries to find a balance, whatever that balance might be, so they try to implement so that both parties feel that they could take some action within the board.
Yeah. And actually, the Bill 60, a lot of the reason the Bill 60 hasn't yet been activated is because they're still writing the regulations to go with it. Yeah,
because they have to define things. What is late and persistent rent?
Yeah,
they have to define these things because they go out in consultation batches. So people could go in there and put some input into regulations. Right?
Yeah.
So these things they're always out there.
Yeah. In fact, actually, something like persistently late, there might be case law on it.
Yeah, and there's case law they have to consider. Right? They have to go back and consider case law because they can't go against the case law and suddenly write something completely different in statute.
Yeah.
Okay? So it's a very evolving place. Like each of them sort of balances off the other.
Yeah. Okay, moving forward, the other, I think, reason why people misunderstand the law is often in that question about what's called the standard and burden of proof, and the fact that we have in criminal law a different standard and burden of proof than we do in civil law. In civil law, it's a case of even how you swear a person in. Although I've seen many court clerks get this wrong. When you swear into civil, you're supposed to swear an oath that you will tell the truth and that you understand that it is a criminal offence not to tell the truth, right? Mm-hmm. Whereas in the criminal procedure, there is that. The swearing in is entirely different. It's a criminal, it's a criminal burden. Swearing in, right?
Yeah, and criminal burden the Crown has the absolute burden to prove, and it has to go beyond a reasonable doubt.
Yeah.
And all the defense has to do is raise reasonable doubt.
Yeah.
Right?
And the mug wasn't. The mug wasn't red; it was green.
Yeah, exactly. And in a civil case, all the plaintiff party has to prove is that 51% or more likely you were right.
Yeah.
That you prove your case in that way. You don't have to go beyond a reasonable doubt. So some cases in criminal law, for example, like a peace bond, also operates on that same principle. But you have to know what the burden of proof is when you're going into any kind of situation.
There's another area that is arguments between parties. Now, whether it's criminal law or civil law, arguments often between parties can be settled out of court.
Yep. Like what can be happening, like if I'm a defense counsel, I often 90% to 95% of these things are pleaded out of court.
Yeah.
Okay, for example, I have a meeting with the Crown. I give the Crown my position on an issue. The Crown gives me their position, and we talk a little bit. And we talk a little bit about the circumstances, what might be appropriate. And then eventually you talk to the client, and if they're accepting of something, maybe we can do away with jail, but hey, he'll go on probation, something like that.
The kind of thing. Instead of charging my client under subsection 1, can you charge him under subsection 3?
Yeah, exactly. We do that in POA as well, Provincial Offences Court. So what happens is you want to substitute a charge sometimes for a lesser charge, particularly a first offense. Right? If somebody keeps getting a charged with the same offense over and over again, I mean, there's other things that need to be done. But most of the cases, most people, they understand the seriousness of all this stuff, where they would talk to the Crown and get this done. And then what generally happens is the Crown and the defense counsel approach the judge with what they call a joint submission. Okay. Sometimes you will both agree on the crime, on the conviction, but not necessarily agree on the penalty. And you can make arguments about the penalty. So there's different things where these things work out, and then that's sometimes what happens. And people always say, oh, they're always getting off on these plea deals. Well, if every single thing that got charged went into the court and had a trial, we're going to be doing this until 2095.
Well, in all honesty, you're not going to hear the case. This year you haven't got any hope of hearing a case that was where John Jones was actually prosecuted in 1992, let alone get to the 2026 cases.
Yeah, exactly. So this is why, because these courts, there's many charges filed in courts. Okay, most of them are minor or relatively minor. Then there's some that are moderate in terms, like, say, dangerous driving offenses, that kind of thing, or maybe fraud, things like that. So these things kind of go in the middle, and then there's more serious offenses like murder, drunken driving that killed somebody. Okay, so there's a number of things that these things all get weighted out between the Crown and defense counsel, and we have there's different steps that go when you're going into a criminal case. And I love doing criminal cases because, first of all, there's a lot of discussion, a lot of bartering, a lot of discussion, a lot of exploration, and you develop the kind of relationships that you really need so that you can get the information you need. If you know the Crown attorney that's involved, sometimes you can get a little bit of help for your client and that sort of thing.
Okay. The other thing to note is of technicalities. For example, cautions in criminal law. You think, why did that bastard get off? Hey, the police officer didn't caution him appropriately when he was being treated as a suspect.
Yeah.
It happens.
It's like the old movie. There's a movie on now about Miranda rights.
Yeah.
Okay? This guy named Eduardo Miranda.
Yeah.
He was charged with some kind of rape of a woman, and he ended up where he was not given his Miranda rights.
Yeah. Okay. And the other questions is that often happens in the courts is, was the correct documentation filed? And I've just spent some time, unfortunately, having a bit of a battle with the court because they were fussed over some spare words that were in one paragraph of an official document.
Yeah, especially when you're looking at the style of cause or something like that. There's different things there, or there could be some misspelling of a name.
Yeah.
Okay? Sometimes it's major enough that it could disrupt or cause the case to go backwards. So these things, you have to make sure these things are done right down to the letter, because this way you have to go and take the proper steps. Everything has to be done properly. In a civil court, it happens to everybody. I've known lawyers downtown here who've been practicing for years. These things happen. They get frustrated at the court because the court comes back.
And then the new version of the document. And then a new version of that document comes out, and on page 5 there's a little checkbox that everybody forgets to check.
Oh yes, a small little wee checkbox,
Yeah.
and then they spit it back at you, and all your $800 comes back.
So then you've got, of course, the other issues, which is common sense versus legal rules, and often we've got all these highly convoluted legal rules out there, and yet a lot of people say, well, if I did X, wouldn't that be better?
Yeah, if you just followed common sense principles, if it's not yours, don't take it. Oh, my body, my rights. Yeah, yeah, there is a common sense thing, and many things come out of that sort of thing from natural human rights and natural person. All that stuff comes from the original of the law. But the thing is, we have to be careful, because if I'm swinging my fist around and you just happen to be in front of me, by the time my fist starts reaching your nose, my rights end and yours begins.
Yeah. Well, also there's another aspect of this is political versus legal. So we have a legal system that has been well balanced over the years, and hey, we can all raise our hands and say, I don't like the law of whatever, right?
A lot of people say, "Oh God, they keep letting people out." And politicians, they're the first to go after, like particularly opposing politicians.
Yeah.
They go after all the laws and start saying this needs to be changed, that needs to be changed. You were in power before, but how come you didn't change it then?
Yeah. Why didn't you do it back then?
Yeah.
Oh, it was impractical to change it.
Yeah.
Thank you.
Like these mandatory minimums, they're not constitutional. Hey? They put mandatory minimums before for certain types of offenses. And then now we're finding that they're not constitutional, because you're not, again, because the crime goes with the criminal and not with the statutory offense.
Yeah. Yeah. All right. So we've really kind of covered a hodgepodge of things here today, and really, so if you need legal advice, you can come, not necessarily on any of the topics that we've covered today. And in fact, today really isn't one of those days where you can get into a specific topic. But if you need legal advice about anything, you can contact Invictus Legal on 905-688-5598, or you can email Angela at weareinvictus.legal, or myself using Peter at weareinvictus.legal. And our website is weareinvictus.legal. Okay. Yep. And if I can show this one.
So what you heard today on Spin Legal, whether it's this show or others in the series, is not legal advice. If you need specific legal advice, then please contact a paralegal or a lawyer. Okay.
Yeah. All right. And I hope you've had a good day today. And we will see you next week, 6 o'clock, and try to be a bit shorter next week.